Hello and welcome to the Space Advisory Podcast. My name is Wanyana Racheal and I am thrilled to have you join us today. Through this podcast, we aim to provide authoritative and incisive commentary at the intersection of space law and security. In today's episode, we will talk about the scope and limitations of international law governing remote sensing, particularly as it relates to state and individual rights. To help us unpack these issues, we have Professor Frans, a globally recognized space law scholar and advisor who has extensively published on space law and provided legal counsel to governments and intergovernmental space agencies on virtually all aspects of international and national space law and policy. We are very delighted to have you today, Professor.
Thank you.
So to set the foundation for this conversation, there are two primary issues which I think that we need to address from the onset. First, regarding the definition and scope of remote sensing under international law, and second, regarding the tension between the principle of freedom of exploration of outer space as a global commons and the principle of full sovereignty of states over their territories, including the natural resources and the information that accrues from their territories. And start with the first issue, the definition and scope of remote sensing. There is no binding definition in international law at the moment. The definition which we have is provided for under the UN guiding principles, which are not binding, but also it is very limited in scope of purpose, catering only to remote sensing for purposes of improving natural resource management, land use, and the protection of the environment. And this means that other purposes outside these three issues are left to the individual discretion of states and supranational unions. So I would like to know from your experience, how do you think this has impacted the regulation of remote sensing, especially now when we see the expansion of remote sensing capabilities, but also remote sensing actors?
Well, I think you already hit the nail on the head. If you look at the definition of remote sensing from a non-strictly legal perspective, it is basically every form of sensing from a remote distance. And of course, we are then talking about remote sensing by satellite. There is also remote sensing by aircraft or even on Earth. But we are obviously talking about remote sensing by satellite. And since satellites are in outer space, as you indicated in the global commons of outer space, the legal ramifications of such activities take on a quite special character. Remote sensing is not, as you also correctly stated, is not defined in the treaties. There is no specific treaty which addresses all types of remote sensing, because if you take the broad definition, it can be used not just for land management, but also for emergency and disaster mitigation, or for military reconnaissance and things like that, even for humanitarian purposes. In some cases, remote sensing is used to discover mass graves as a result of mass violations of human rights. But the only legal document which we have, again, as you pointed out, is this set of UN principles going back to 1986, which as principles as such are not strictly legally binding. However, they have generally been perceived to come to represent customary international law, because most relevant states, and with relevant states in this context, we should think about the states that actually are able to operate these systems, have by and large followed the approach and the suggestions and the recommendations of this set of remote sensing principles. But as you also pointed out, they are limited by their own nature to nature remote sensing. To remote sensing for natural resource management purposes and everything related to that, which indeed leaves the rest of the question wide open. And because of the fact that we're talking about remote sensing in outer space using satellites, and outer space is an area, a global commons, where freedom is the baseline, freedom for states is the baseline. And that means by definition that any limitations to that freedom can only be imposed by international law, by international agreement, by international treaties. So unless there is a specific treaty which prohibits the certain use of remote sensing satellites and their data, that use and those data are basically free. So I think that's the starting point. And the question that you then touch upon is, of course, to what extent does that freedom interfere with another fundamental principle of international law, the sovereignty of states over their territory? And how do the two, to the extent that they might conflict with each other, give rise to a clear hierarchy of whether the principle of freedom rules supreme or whether the principle of sovereignty rules supreme. My sort of summary is that at the end of the day, it's the principle of freedom which overrules the freedom of sovereignty, as long as it concerns the operation of satellites in outer space. So the mere fact that a satellite of one country is remote sensing another country, as such, again, unless you can point to a specific international obligation dictating otherwise, as such is not prohibited. And that even means if that satellite operation will give the satellite operator information about a certain territory that the state of the territory itself may not have or may not be aware of. If you look at the principles, and that's why it's correct to mention them here once again, you do see that there is an effort to create a kind of a balance between the two. But ultimately, the idea is that the sensed state, the state whose territory is sensed by another state or by the satellites of another state, has only a right of non-discriminatory access to those data, which means that it doesn't have a right to prohibit the remote sensing as such. It doesn't have an exclusive right to the data, claiming that is part of my sovereignty. It doesn't have an exclusive right or even a preferential right to saying I need the data for free, unless other states get the data for free as well. So that is, unfortunately for the sensed state, not much of a right. And if you then ask yourself, well, what does that mean for the sovereignty? The sovereignty of the state, by definition, only pertains to its territory and its airspace. So while any state can prohibit remote sensing by aircraft in its airspace for whatever reason that it sees fit, it cannot do so when it comes from outer space. What it can, of course, do, however, is to prohibit any sale of those data in the territory, because that's where the territorial sovereignty, of course, plays a role. And if the fear is, and I'm afraid that in many cases that fear might have been justified, if the fear is that the satellite data give a foreign country, in particular in most cases a rich Western country, an advantage of knowledge over the national resources in a developing country, in a non-sensing state, then the only way to use the sovereignty is to make sure that you still are entitled to those resources in any event. So if some foreign operator approaches you or your country wanting to you because of the data, being aware that there's maybe rich oil or mineral deposits in your country, and wants to arrange a cheap contract, then the suspicions on the side of the country which is so requested should immediately be up. And there should be a thorough investigation seeing whether the concession that the foreign operator is looking for might be much more worth than they pretend it to be. And the lucky thing is that with the increasing amount of commercialization and of satellite data, with more commercial players, it might be possible even for a non-sensing country to get access to some data which somehow can tell that country what the value of its resources might be. So I hope it's a very extended explanation for which I apologize, but I hope that sort of answers your question.
Yes, a very elaborate response. And you hinted on the lack of exclusive rights or sovereignty over data that is acquired from outer space over a territory. And this leads me to wonder, because many national laws from major space actors seem to be moving more decisively from free exploration to strategic control. For example, the US now subjects all its private US remote sensing systems to a detailed licensing regime. It also has shutter control policies which restrict a company's ability to collect or disseminate imagery over specific areas. We also see similar comprehensive licensing policies and laws for operators in Germany, in France, and also Canada and India. So this now makes me wonder if it's a question of who has the power to be able to determine the kind of access that other actors or remote sensing actors can have or do with the collection of data from their territory. How do you balance this to ensure non-discrimination, so that it's not only the developing countries that are mostly bearing the burden of these principles, if I can put it roughly like that?
Yeah, well, that's a great question, and unfortunately, the answer is that there are no absolute guarantees. As we discussed, the closest to an international regime addressing the issue of freedom of remote sensing, but also the obligations of the sensing states in terms of dissemination, doesn't go very far, because the obligation of, it's not even non-discrimination, it's on a basis of non-discrimination. And one of the elements that you could see from practice is that it doesn't mean automatically that the sensing state has to share the data with every other state on an equal basis, because discrimination or non-discrimination can also be still applicable if the states are different. To give you one example, there is in Europe there is an organization called EUMETSAT, the European Meteorological Satellite Organization, which generates a lot of data for weather purposes and for climate change. Now, EUMETSAT is an international organization of more than 20 European states who together contribute the money for the satellite system and operate the ground stations, etc., etc. If these satellites generate interesting data, the reasoning is, well, we may discriminate between EUMETSAT member states because they participate in the costs of the whole operation, and non-EUMETSAT member states because they don't participate. So even though you make a distinction between two groups of nations, that legally speaking is not considered discrimination. And another example would be that if one state operates a remote sensing satellite, and there are two states that are interested in those data, even if one of the states is the sense state itself. But the other state is saying, well, in return for the data, we offer you the possibility to do business in our country, or we offer you the possibility to operate a ground station here. And the other state, the sense state, does not offer that possibilities. Then again, the sensing state is not discriminating between the two states if it is one state giving the data and not to the other, because the one state is giving something back. So the whole idea of non-discrimination doesn't go that far as to simply say everyone has the same rights, because that depends upon the whole context. And one reason I go back a step. First of all, one of the or two of the most important principles of space law, and that's not just remote sensing, but that's the Outer Space Treaty, which is of course binding upon everyone. That's a black letter law treaty that provides for the responsibility and liability of states under Articles 6 and 7 respectively, also for any private operations. So it basically means that states shall guarantee that not only themselves and their national space agency, but also any private operator operating under their control should comply with whatever rules there are in outer space. And unfortunately, as we said, in terms of remote sensing, there are not that much yet, but you can imagine that when it comes to other areas, there are a number of rules which apply. So the state should guarantee And further to that, they are also actually going to be held liable if these operations cause physical damage. And as a consequence, there is an inherent stimulation by states to control, as you rightly put it, those satellite operations, because the states are going to be held responsible and liable. So they want to make sure that they only allow private sector activities which do not run much of a risk of violating international law, or which do not run much of a risk of causing damage. And that's where the whole licensing obligation comes from. And I think as such, that's a good thing, because it makes it does not allow a country to say, well, you are claiming that my private company has created an environmental disaster in your country, but try to sue the company because we are a national state, we were not involved. That's none of our business. You can't make that argument in space, and I think that's such a good thing. Now, of course, it also means that the licensing obligation that national states impose, and now I'm going specifically to the remote sensing context, is also used to include, and that's the logical thing, I would say, to include other interests of the country at stake. And when it comes to remote sensing, you can imagine that in particular, when it comes to military or political issues, there's a lot of interest in the home state to make sure that the satellite data, which its operators that are going to be licensed want to disseminate as much as possible, because a private operator basically is willing to sell them to anyone who cares to pay for them, and as much clients as possible. But it's the state then who says, no, I don't want you to sell the satellite data to these particular clients because we have, for example, a national security interest in not allowing those data to go abroad. And you mentioned the German and the Canadian laws. They were specifically focusing on these potential security considerations that remote sensing data might generate. It is national security. It sometimes is also policy. Of course, everyone knows that the United States is a great protector of Israel's interests. That has to do with a long historical and political situation, which we don't need to go into now. But as part of its foreign policy to try and protect Israel against perceived enemies, licensees of the US authorities for remote sensing operations cannot sell data on Israel regarding the territory of Israel, which are more precise than data that would be available elsewhere. So it gives them the right to do so because it's their operators. They can even prohibit their operators from undertaking remote sensing activities altogether. And even though clearly you may disagree with the policy, that is the United States sovereign right to do so. Now, coming back to your original question, how can we do something about that? The only hope is that so many countries are operating satellites that there will be one who is willing to share the data with you. And you mentioned India. India has, of course, ever since its independence in the late 1940s, prided itself on being a leader of the third world, of the global south, of that part of the world which wasn't aligned to either the capitalist bloc led by the United States or the communist bloc led by the Soviet Union at the time. And they don't care. They might not care about potential commercial or policy interests of the United States or France or Germany if they have satellite operators which share data, which are able to disseminate data, to generate data. They might allow them to share the data with anyone who they do not consider to be against the Indian interest. And of course, the more countries and the more private operators you have operating these things, the larger the chances are that even a country like your country, for example, could find some access, some operator willing and legally able to share the data with you. Because that's, of course, the flip side of the freedom. The United States cannot dictate to India that India should not share its data with other countries that India thinks interesting, just because the United States doesn't like it. Unless we go to the realm of power politics. But that's sort of the situation.
Which is very interesting and also very complex. I think politics has, of course, it has always had a very significant part in all of this. But also, I would like to moot, if I can put it like that, moot something that I've been thinking about regarding state territorial rights, the rights of innocent states. That there
Yeah.
seems to be a shortage of appreciation of the deterritorializing and reterritorializing effect of remote sensing technologies. These functions, I think, consist of first of all, aggregating territorial data of a sovereign territory, and which data is then analyzed, reinterpreted, and used to perform functions that are traditionally in the exclusive purview of the state in its exercise of authority over its physical territory. First of all, do you think that remote sensing has a territorializing power or effect?
What do you mean exactly by territorialization?
For example, you look at remote sensing data can be used to surveil and map maybe land use, resources, or population
Yeah.
movements to inform plans for expansion of a settlement. And I consider this de facto territorialization in itself. But also there is the aspect of data territories or something like when this data is aggregated about that is collected from a particular physical territory, it then I consider it to become a data territory or territory of data. What do you think about this phenomenon?
Yeah.
Do you think maybe to pose the question more clearly? Do you think that remote sensing data should be treated as a subject of territorial claims instead of, because I know you have written about copyright law as a tool of, of regulating remote sensing, and you have talked about licensing. Do you think we should also consider territorial claims?
I think that will be very difficult in the current context because technically speaking, remote sensing is nothing but generating information. And of course, you can generate information which is potentially very valuable. I gave earlier the example of generating information on the potential for mineral resources, which you can sometimes detect from outer space. There's clear advantage in military and security context, but we are not discussing that. But if you talk about things like urban sprawl and which way is a community growing or where's the traffic going, that information can be generated freely. But before a foreign state can do something with that information, step in and start regulating the traffic, or step in and do something about the urban sprawl, that is something they cannot do. So the moment you actually territorialize the data, and in the sense that you are going to do something down on the ground in the country where of which the remote sensing data over which the remote sensing data are generated and which show details, then of course the sovereignty of the country comes back into play, and the value of the data are limited if you can't really do anything with them. And again, maybe for better or worse, but the whole idea of sovereignty has been framed in international law very much in a spatial sense, in the sense that it's a concept which first and foremost, and that's why we call it often territorial sovereignty, is linked to an area. And then of course we have agreed that it expands a little bit into the oceans. The territorial waters up to 12 miles offshore are also, legally speaking, under the sovereignty of the home state. There are just a handful of exceptions by treaty law, such as innocent passage. Vertically, we have since more than a century agreed that airspaces where aircraft fly are a vertical extension of sovereignty, and as a consequence are also part of the geographical realm where a state is sovereign. But for better or worse, we have also agreed that somewhere above that, and the question is then, of course, where exactly is the boundary? There is an area which is outer space, which does not fall in under sovereignty. And even though things may happen which have an impact on the actual exercise of sovereignty, as long as these things do not happen in airspace or on the territory, then it is very difficult to agree on limitations, because again, that has to be at the international level. A very illustrative point here is when you compare it to the use of satellites for telecommunications. Telecommunications as such have a direct effect. If you broadcast television programs into a particular country, or if you allow telephone calls via satellite to go to a particular country by a satellite of another country, then you have a direct effect on the territory, and that allows the home state, the state, the target state, so to speak, to say, I don't allow you to broadcast certain programs into my country, and I certainly don't allow people in my country to listen to them, and I don't allow you to sell your services to people in my country, because I disagree for whatever reason with these operations. But that is because once the telecommunications signal, as an active radio signal, comes into the territory, it interacts with transmitters on the ground, with handheld phones on the ground, with radio receivers on the ground, and all like that. And that brings in a clear part where the sovereign state can say, we don't want any of that. Iran is famous for prohibiting the use of satellite dishes, because they don't want their population to have access to certain Western programs. But the key difference is that with telecommunications, these satellites actually have a direct effect in someone's territory, in the airspace and on the ground of some state, whereas the remote sensing satellites only observe. Even if they use radar to do so, it doesn't make any. Nobody feels the radar. Nobody hears anything. Nobody. So that is why it is very complicated to extend the right of states to the satellites themselves. I don't know whether that answers your question, but these are, I think, very important elements to be taken as a baseline. Upon then, at some point in time, there might, unfortunately, today's world is not very likely to see that happening, but maybe in the future, when things become more peaceful again, things may be changing, that we can agree on an international treaty addressing these things already as for outer space.
Thank you very much. I think you very well answer the question, which I will be exploring with you further outside of the podcast, because it's an issue which is unconventional and maybe not legally sound at the moment. But I would like to explore it a little further, because critical geography, international relations, critical security studies, they recognize these territorializing, functions or effects. And also we are seeing these recognitions within, for example, data regulations around digital sovereignty and digital territories. So I wonder if it can be also transferred within the space domain. But this is something that we could explore later. Okay, so now we have quite elaborately talked about the rights and obligations of sensing and sensed states. Could we now talk about the rights of the individual in the context of remote sensing? Because international law, or international space law as it is right now, does not explicitly recognize or extend protections to individual rights in the context of remote sensing. So I'm keen to know from you, do you think this position is still tenable with the proliferating commercial actors, but then also the expanding capabilities of remote sensing, with the ability to for surveillance, mass surveillance, continuous surveillance, and the implications for personal privacy protection, data protection rights, and also the rights against surveillance of individuals from space. So we could start from there. Do you think this position is still tenable, or is it apt to leave the matter of regulating remote sensing in the context or as regards to individual rights under the jurisdiction of state nations and maybe international human rights law?
Yeah, is it tenable? I would say that in if you look at real life, the results of these developments that you just sketch in some detail are clearly that there are major concerns with privacy rights, data protection, etc., which have clearly not been taken on board of international space law, and certainly not when it comes to remote sensing. Partly that is because the 1960s and 70s treaties, which still form the core of space law, in those years, remote sensing was never of a resolution high enough to raise major concerns in the context of privacy issues of individuals. Even a decade or two later, when the 1986 remote sensing resolution, which as such is not binding but has been generally recognized to reflect customary international law, came about, even then in the mid-60s, that wasn't really a big issue. So it's only really something of the last 1 or 2 decades, I would say, a quarter of a century at most, where this problem has in the real world become acute, and then gradually we can acknowledge that the legal situation addressing it is far from ideal. And perhaps the best way to explain it is also that there is a clear disconnect between international space law, which addresses mainly the rights and obligations of states, and then requires states to make sure that their individual citizens and companies also comply with those rights, and the national legislation, the national regimes, which most states have, which address these issues of individual privacy rights and protection against government intrusion or things like that. And as you can imagine, on the latter part, every state has its own take on privacy rights, and in particular the balance between the rights of individuals to privacy and the rights of the government in particular contexts. Think about public order, policing against crimes, or even terrorist activities and national security, to interfere with personal privacy. And if I just take as an example my home country, the Netherlands, even though privacy is generally very much valued in our society and in our law, there are exceptions whereby the police or national authorities can interfere with privacy or can break privacy considerations if there are serious criminal law or public order or national security issues at stake. But then it has to be regulated, then it has to be as per certain procedures, which sort of supposed to guarantee that these rights of the government are not abused, and that they are really only used when there is really a concern for criminal investigation or public order. Now, the disconnect is that, of course, every state not only has its own set of privacy rules, and in some cases it's more strict than in others, but they basically apply on the territory of that particular state. And as soon as somebody crosses borders, a different regime may apply, and then outer space is not anyone's territory, which means that no state can apply its privacy laws directly to outer space, including to satellites which may interfere with those privacy laws. And as we are aware, since the baseline legal rule for outer space activities is still the freedom for states, including the freedom to generate information, there is a disconnect there. Ideally speaking, yes, we should then develop a counterpart to this freedom to honor valid privacy rights of individuals. But given the disconnect and given the difference between individual states, I unfortunately find it extremely unlikely that there will ever be some consensus on what type of privacy protection against satellites people actually are entitled to. So, in other words, if you as a state, you are really concerned with the privacy of your citizens because of satellite operations, of satellite remote sensing, there are a couple of things you can better do, which are more likely to be successful than trying to establish an international legal regime doing that. And that's basically contacting the operators and trying to come to some understanding with them individually on an individual basis, to prohibit the sales or use of those data on national territory, just like, for example, many countries have laws against child pornography, and even though the pornography itself may come from other countries, the countries are able to take measures if somebody on the territory broadcasts it or uses it or consumes it, and that is a tool which states do have at their disposal because they are sovereign over the national territory.
Oh, wow, that's a very elaborate response. Thank you very much. And one last one for us to close. Which direction do you see remote sensing taking the foreseeable future? We are seeing a trend towards bilateral space shuttle diplomacy. For example, we have the Artemis Accords, but then also, just like you mentioned, in the context of, for example, protection of individual rights, we have national laws which are mostly fragmented. Do you think that this patchwork approach, if I can call it like that loosely, while messy, do you think it offers a more realistic and adaptable path to the governance of remote sensing than seeking a universal treaty?
No, unfortunately, it does. It's certainly not the best or even the second best solution. But unfortunately, if you ask me, to try and look into a crystal ball, I'm afraid that that's where it will be going. The only hope is that, but this carries its own risks. The only hope is that there will be sufficient true competition, and then I don't mean the kind of competition which some of the major tech companies, in particular from the United States, currently see, that they are basically the monopolist and can dictate all the terms. But if you have real competition, the essence thereof is that there is no single provider of satellite services which can dictate the rules and which can impose its own personal or subjective approach, but that you have so many operators that individuals can use the ones which they feel most happy with. That still doesn't mean that you can solve the issue of privacy, as we spoke about under the previous question, but that's something which would at least guarantee that data which do not violate any laws or specific high-level human interests are indeed widely made available, and not just available to a happy few who can either afford it because they have a lot of money, or who are happening to be in the right country, which allows them to share the data with people outside of the country not being allowed to share them. In that sense, the fact that remote sensing technology, as we speak, becomes more and more capable of showing details, becomes more and more high resolution, and at the same time likely becomes cheaper, that is probably the best guarantee against a world where there's a handful of countries which jealously guard the technology and only use it for their personal or for their national interests, as opposed to for the broader interests of humanity. But that's a very difficult path that's fraught with complications. And as I said, the fundamental requirement is that you do have indeed a number of companies, and not just two or three, who can easily escape governmental controls and who can also dictate what the consumers will be getting. I hope that's an answer to your question.
It is. It's a very adequate answer. Thank you very much. And again, thank you very much, Professor, for joining
Thank
us
you.
for this episode on remote sensing. I believe that the listeners will find your perspective and your input and your views very insightful and very educative. Thank you very much again.
Thank you.
All right.